Hello, everyone, and welcome back. This week, we're going to be covering two chapters in our book that are about intellectual property, and it will cover copyright patents, trademarks, and trade secrets. So these are chapters 7 and 8 in the Digital Media Law Book, second edition by Ashley Packard. So I want to start by talking about contributed photos. And the reality is we can't just pick up photos from the internet and put them on our website or on social media or in, say, our student publications without having the permission of those who own the picture. And sometimes there's kind of this giveaway. So when I see a picture in the paper or on a website and it has a credit line that says contributed photo, well, it kind of makes me stop and pause. Because what I figured out for over the years about this phrasing, contributed photo, it often means stolen or at least taken without permission. So, and if you don't ask anyone for permission, this can be a problem. This sometimes happens when journalists wait till the last minute to find a photo, and then they're desperate to fill a spot on the page, or it makes the page look good because it adds some art to it. But the reality is they didn't do enough planning. So they grabbed a picture off the internet and tried to use it. This can have legal issues. Well, legal consequences is probably the better phrasing for it. The right way to go about using a picture, of course, would be to contact the person who owns the picture and ask for permission to put it in the paper or on your website. And in some cases, you can find pictures that are in the public domain or pictures that are covered by something like Creative Commons copyright. That's something we're going to talk about today, which gives you the ability and the right to use them if you follow certain rules. So these are some of the issues we're going to be talking about in this lecture. The key word for today is copyright, because that's what everything we do and discuss this week will have to do with copyright. And copyright is the ownership that somebody has over a piece of work. Why do we worry about protecting intellectual property? The United States Constitution gives the government the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The rationale behind this is that people will produce more creative work if the fruits of their labors are protected and if other people who did not contribute to their work cannot exploit it. But there is another side of this coin. Intellectual property protection has to be balanced against the notion that after a certain amount of time, that work should move into the public domain, where others may use it to contribute to the body of knowledge. Apple's dictionary app, which you may have on your computer if you have a Mac, defines copyright as the exclusive legal right given to an originator or an assignee to print, publish, perform, film or record literary, artistic, or musical material, and to authorize others to do the same. These are some of the kinds of things that you can copyright: artwork, literature, music. Music copyright is a really big area that could be its own lecture, could be its own class, because there are a lot of lawsuits having to do with copywriting and sampling of music that we don't really have time to get into. But I highly recommend you looking up some of the American musical artists who have gone through copyright issues because they've sampled other people's work or other people have sampled their work, and kind of where we fall in that continuum of copyright. Also, video, images, and software. In fact, you can copyright original works of authorship fixed in any tangible medium of expression according to U.S. law. These tangible media include film, paper, video, computer disk, read-only memory, and random access memory. Those last two things, if you're not familiar, um, exist within the computer. But essentially, anything that can retain information can be copyrighted. Your work must display a minimal level of creativity, though. It cannot be a collection of very mundane facts that you put together, but if it has some degree of creativity, it is probably copyrightable. Of course, there are some things that you can't copyright. Facts and ideas cannot be copyrighted because other people need to be able to use the same information. As long as they don't express it in the same way as you did without giving you proper credit or having your permission. So you may be able to copyright a compilation of facts, but not all compilation of facts. For example, a fax and telephone directory is a compilation of facts. I don't know how familiar you are with paper telephone directories. We used to have them in the United States before the internet, and some places still have them, but we don't use them as much as we once did. When I worked for the newspaper in Mississippi, I used my phone directory regularly, multiple times a week, and I was really felt like everyone must use it all the time. And this, of course, was after the internet had come around. We were on social media at this point, but it was still something that was an essential part of how I did my job. But this was also before many people stopped using landlines as their primary phone number and moved to cell phones. So it was, you weren't calling their cell phone. But telephone directories are a big collection of people's names, addresses, and phone numbers. And it does involve a lot of work to put these together. But there's a case in the United States that says it is not a copyrightable enterprise. Somebody else can pick up that list even though you put a lot of work into it and use that list without violating your copyright. The Supreme Court said the main purpose of copyright law is not to reward authors' labor, but to promote science and useful art. However, the European Union does protect databases. You also cannot copyright stock or standard expressions of an idea customary to a particular genre. So this is called scenes affaire. I hope I'm saying that right, but you can see it on the screen there. For example, you can have two different video games that depict karate opponents in a match. And they may be very similar, but neither one of them's copyrighted. The other one has the right to use that material and have a similar setup because it's the common way that karate, for example, works, and it's done in that situation. Titles and names cannot be copyrighted. Typefaces such as Helvetica, Ventura, or Georgia, and many others cannot be copyrighted. But the software that produces those typefaces can be copyrighted. The United States government documents cannot be copyrighted. They are produced by public employees on behalf of the government, which I've expressed before belongs to everybody. But works produced by state or municipal governments may be copyrightable. Depends on what their policies are. A few years ago, we have a cell phone company called T-Mobile in the United States, and they tried to sue someone else for using their branding color scheme, saying that it was it was their copyright to use that color. And they lost that case because you can't copyright a CMYK or RGB. You can say that this is the color you always use as part of your branding, but it was not upheld in the court of law. I just think it's kind of a fun case. Here's a list that is in our book, and it summarizes some of the things that can be copyrighted and some things that cannot be copyrighted. You can pause and read it, or you can look it up in your book. So who gets copyright protection? Copyright protection vests in the creator or creators of the work at the moment the work is produced. If you are preparing work in the scope of your employment, for example, from pay by the employer may have the copyright because it would be considered a work for hire. A lot of universities have rules around when professors, faculty do certain types of research or work, create companies from this research because they want some of that money. So they want some copyright protection, not just for their employee, but so that they get some money as well. Copyright gives you the exclusive rights to reproduce the copyrighted work in copies or sound recordings. The legal term of sound recordings is phono records. You have the right to prepare derivative work such as new editions, translations, and dramatizations. You can distribute copies. You can perform the work publicly. You can display the copyrighted work publicly. You can perform it by digital audio transmission, and you can transfer all or some of these rights to other people. In the United States, copyright is protected by federal law, not state law or common law. It is not necessary to register a work officially through the Copyright Office in order to protect it. All works created since 1978 have been protected upon creation, consistent with the International Berne Convention for the Protection of Literary and Artistic Works. Under this convention, scores of member nations recognize one another's copyright. So why should you even register for copyright? Well, if you want to sue for copyright infringement, you must be registered by that time. Now, you can register for copyright after the infringement takes place, but this can cause a delay, and it can also limit the amount of money you can collect from the person who committed the infringement. You register in the United States by submitting a completed application form and a fee, which is usually about $55 in US money. With the conversion rate, that's about $250 in Malaysia. You also have to submit 2 copies of the work if it's already been published, or 1 copy if it's not yet. And this is so it can be deposited in the Library of Congress. There's no such thing as what some people call a poor man's copyright. You can't establish a copyright by placing a work in a sealed envelope and mailing it to yourself with a government postmark. That might have some useful purposes in terms of proving, I guess, when you created the work, but it doesn't create a copyright for you. You actually create your copyright when you create the work, but if you're feeling like you're going to have to really protect it, then you need to register for that copyright. You have probably seen this C in a circle before. That's the copyright symbol. It is not required for you to affix a notice of copyright to a published work, but it is advisable because it can serve as evidence that the infringement was not innocent if someone does that. A copyright notice consists of 3 elements. So it can include the circled C or the word copyright or the abbreviation, the year the work was first published, and the name of the copyright owner. For example, if I created something and registered my copyright, it would look something like this. Little circle, copyright 2020, Andrea Hall. This is a screenshot from the Copyright Office that belongs to the Malaysian government. I haven't looked into the details of how this works, But you can go to this site to find out more about how copyright works specifically in Malaysia. One particular area of interest to young people is the idea of file sharing, music files in particular. Sharing copyrighted music, games, and videos is infringement of copyright. Early in the internet days, this was a bigger problem than it is now because we didn't have things like Spotify or iTunes or Apple Music where we are able to subscribe and pay. It was just a lot of people downloading and sharing music through things like Napster, and this was problematic. So, over a 5-year period, the Recording Industry Association of America filed suits against more than 30,000 people who traded files this way. The most renowned case was against Jamie Thomas Rassett, who was fined $1.5 million in 2009 for willfully infringing 24 songs. The RIAA said she had traded as many as 1,700 songs on the file sharing network Kazaa. She was ultimately ordered to pay $222,000, so not the $1.5 million. Jamie was born in 1977. She's a Native American mother from Minnesota. And based on what I've read about the case and her, I don't think that she was probably able to pay a judgment that big. But in December of 2008, the RIAA announced its intention to abandon new lawsuits against individual file sharers, which had basically become a public relations fiasco. It was making more enemies than it could afford by filing all of these suits. Once again, these were coming in the early 2000s, late 1990s for the most part. The United States has a law called the Digital Millennium Copyright Act. It makes it illegal to circumvent digital rights management technology directly or to, quote, import, offer to the public or otherwise traffic in any technology, product, or service that can circumvent technological measures used to control access to copyrighted works. Now, there is such a thing as fair use, which is an attempt to balance the rights of owners and users. Fair use allows the public to make limited use of others' expressions, even if they are copyrighted. Fair use can include criticism, comment, news reporting, teaching, which is one that I use, scholarship, and research. Courts determine what constitutes fair use on a case-by-case basis by assessing the following 4 factors. First, the purpose and character of the use, including whether it is for profit, nonprofit, or education. Second, the nature of the copyrighted work. Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Substantiality could be a reference to what percentage of the work you are using. So if you're quoting a 4-line poem and you quote the entire poem, that is certainly a substantial portion because it is the entire thing. But if that poem consists of 200 lines and you quote, say, 4 lines, then it may not be a substantial portion. The 4th criterion is the effect of the use upon the potential market for or value of the copyrighted work. If you're going to diminish the value somebody can get out of his or her work by what you publish, then you're infringing on this. Parodies are often or normally considered fair use. Weird Al Yankovic, if you're not familiar with him, has built an entire career off of parodying others' music. So, and parodies are basically where you're making fun of something or poking fun at something. When it comes to fair use, hyperlinking is usually okay. You can hyperlink to somebody else's website and not worry about violating copyright. You can see a lot of copyright material here on YouTube and Vimeo and services like that. They have often made agreements with users and paid licensing fees that permit you to embed their content. In other words, YouTube may have paid a fee to, say, the music industry so that song you're putting up can be published on YouTube. On social media, it is generally better to link to an interesting article or photo than to copy and repost it. Sites like Twitter and Facebook have a legal right to use the content that you upload and to sub-license the use of that content to others, such as advertisers. We kind of talked about this a little bit. So you're giving up some of your copyright privileges when you post something on Twitter and Facebook. So you need to read those terms of use and know what you're doing. We come back to those terms of use. And I know we all tend to just skip over them, but there's a component, of course, of copyright to them and whether or not you truly own the content that you put on their sites. And as I mentioned before, sampling, it's part of fair use to some extent, but there's been a lot of cases about this in the last decade. But sampling is a concept that involves incorporating a portion of a sound recording, video, or photograph into a new work. So when YouTube detects copyright content is on something you've uploaded, it may block it. Or on the other side, it may monetize it in some way that benefits the rights holder, such as offering a link to buy the work online so that the copyright holder gets some benefit from your post. The best way to avoid a copyright suit for the unauthorized use of music is to license the song before incorporating it into your work. Now, when you find something in the public domain, you are free to use it. There are works that never had or no longer have copyright permission or protection. Classic literature, stuff that was published hundreds of years ago, may be in the public domain. These works are freely available for anyone to use anytime for any purpose. I mentioned this earlier in our lecture, but I strongly recommend that you look into the Creative Commons concept. Creative Commons is a nonprofit organization that provides a mechanism to allow copyright holders to license certain uses of their work that they consider acceptable while retaining control over other uses. And the Creative Commons website provides directions for licensing and lets you locate things that can be modified, adapted, built upon, or can be used even for commercial purposes. But you have to find a certain notice in accordance with the requirements of the Creative Commons copyright. So this will give you a lot of protection if you want to use something that somebody else has made by making sure it's covered by Creative Commons. And when you go to the Creative Commons website, you'll see that there are different levels. So some images may say that you have to give credit to the photographer or to the musician. Others will say if it's for this purpose, you don't have to say who created it, but if it's for another purpose, you do. So the Creative Commons license is expressed as a CC within a circle. And when you see that, you know that they are free. Now, they're not meant to serve as a substitute for official registration, but they are legally enforceable and will terminate if abused. This is a screenshot from the Creative Commons website. You can go there and get more information about that. And as I noted, you're actually able to find material that's covered by Creative Commons copyright right in here. And it's a very easy to use website. You do have to, of course, read through to make sure you use everything properly. But working for a magazine, we use Creative Commons quite a bit for some stories. We also, paid to use some pictures when we wanted to, make them big or really have them as a bigger piece in our magazine. Now let's talk about patents, trademarks, and trade secrets. Intellectual property is commonly divided into two categories: copyright and industrial. Copyright protects literary or artistic works. Patent, trademark, and trade secret law protects industrial property. So this category encompasses all digital media, devices, and products, as well as the words and symbols used to market them. Patent law protects inventions, processes, devices, and methods. It applies to digital media devices like computers, flash drives, DVD players, and MP3 players, and some software. The same section of the Constitution that directs Congress to protect copyright also empowers it to protect patents by securing investors exclusive rights to inventions and discoveries for a limited period of time. Unlike copyright law, though, the duration of protection is much more limited. So, as I already mentioned, copyright protects works for the life of the creator plus 70 years. Patent protection lasts 20 years from the date of application. Protections for patents is not like copyright protection. Protection patents is not automatic. Even if the invention or discovery qualifies for patent protection, the creator must show that it meets 3 criteria. It has novelty, it's useful for some purpose, and it's not obvious. In 2011, Congress passed the American Invents Act, which harmonized the U.S. patent process with those of other countries by awarding patents on the basis of first to file rather than first to invent. One function of that act, and this is perhaps the most interesting thing I found in this chapter, just in terms of like pure human interest. One function is to allow for review of bad patents after they are granted. So, for example, somebody managed to obtain a U.S. patent about a method of exercising a cat by directing a beam of invisible light produced by a handheld laser apparatus onto the floor or wall or other opaque surface in the vicinity of the cat, then moving the laser so as to cause the bright pattern of light to move in an irregular way, fascinating to cats. I bet you have seen cats all over the world, or at least in your part of the world anyway, exhibit this kind of behavior. I don't think it is something that can be patented. It's not novel. It's not obvious. I mean, it happens everywhere, I'm just not sure how useful it is to patent this behavior. So you can go back and look at those 3 bullet points from the last slide and see that, it didn't really meet that criteria. There's also another patent for something called the bread refreshing method, but most of us would just call it toasting. When your bread gets stale, it tastes better if you toast it. This did not need to be a patent. Trademark law stimulates the economic marketplace by promoting competition. And it protects consumers from misleading packaging and ads that could confuse them about the sources of products and services. So if you go to KFC, you want to know it's really KFC and not some cheap imitation. It gives manufacturers an incentive to produce quality products and services. We have different kinds of marks for these. They are names, words, slogans, symbols, pictures, or a combination of these different elements. So a trademark, such as the Coca-Cola logo, identifies goods already in or intended for commerce. A service mark, such as CNN's logo, identifies businesses in the service industry. And collective marks such as the Block R used by the National Association of Realtors in the United States identify membership organizations. Other aspects of a brand's image and appearance, such as packaging, color, size, and shape, may acquire protection under the term trade dress. So, in the United States, when you buy or sell a house, you often hire or work with someone whose job it is to help people buy or sell property. In kind of everyday communication, at least in the United States, we often refer to them as realtors. However, the term realtor with a capital R actually refers to individuals who buy and sell houses and who are part of the National Association of Realtors. You can see their logo here at the top. But we often just call anyone who sells home a realtor. But the AP Style book, which you can see notes here below, says that you can only use realtor if there's reason to indicate that the individual is a member of the National Association of Realtors. Everyone else is called a real estate agent. So that also means you shouldn't call them realtors with a lowercase r either, because it's part of the trademark. Companies try to preserve their trademarks and branding, and they want journalists to respect that. For example, if you're writing about Coca-Cola, you would know to capitalize the C's at the beginning of Coca and Cola. But what about when you say Coke? Do you need to capitalize it? The answer is yes. You need to capitalize the C in Coke because it is a trademark. And you can see an example of how Coca-Cola uses the capital Coke in their branding. It's also important to remember that you are not using the word Coke properly if you're just referring to any soft drink. Coke refers specifically to Coca-Cola. You can acquire common law trademark protection by being the first to use a particular trademark in commerce. However, protection for the mark will be limited to the geographic area in which the product is sold. To acquire protection of the mark throughout the United States, you must officially register it through the Patent and Trademark Office. Trademark infringement and false designation of origin are illegal because the fraudulent use of a mark is likely to confuse consumers. It's not to protect the mark or its owner. The purpose of the Trademark Act is not to secure the owner's goodwill, but to avoid confusing consumers. This is an illustration from the book about cyber squatting, which means registering an internet domain name that incorporates someone else's trademark with the intent to sell it back to the trademark owner or to profit for the trademark owner's goodwill. And of course, that is illegal. We previously have discussed cyber squatting, but something kind of funny, I suppose, or something I found amusing was this idea of typo squatting. Basically, this means registering a domain name that includes typos that users might commonly make when they're typing in the name of a website and taking it to a website that looks like an official website but is not necessarily the official website. So if there was a common way of, say, misspelling Coca-Cola, you might register a domain name spelled that way, or maybe you choose something like Coke, K-O, or COKE.com, I'm not sure if that's a thing or not, in order to get people to come to your website instead of the official site, or to get Coca-Cola to buy Coke.com from you so that if people did type that in, it could redirect to their official site. A trade secret is a confidential formula, pattern, compilation, program, device, method, technique, or process that offers its owner an economic advantage over competitors who do not know it. Protecting trade secrets is thought to encourage research and development that supplement the patent system. For example, even before you register a patent as the inventor, you want protection of the trade secrets that are going into the development of that patent. Trade secret protection is perpetual, but once the cat is out of the bag, then the protection ends. Most US states prohibit misappropriation of a trade secret. That's when it's acquired or disclosed by someone who knows or has reason to know that it was acquired improperly, and its use is unauthorized. Increasingly, cases that are filed for misappropriation of trade secrets involve information published by bloggers. So if you're a blogger, you can get in trouble by divulging a trade secret. Here's another illustration from our book. This is Coca-Cola's vault located in Atlanta, which is in the state of Georgia. Geographically, Georgia is one of our neighboring states here in Alabama. And you should know that I'm a huge fan of Coca-Cola. I have been to World of Coca-Cola on several occasions, and I have been to see kind of the vault area. It's part of the tour. And of course, I love to taste the sodas from all around the world. So the Coca-Cola vault is where they keep the secret formula that makes Coca-Cola taste different from, say, Pepsi or other brown soft drinks, essentially. And it is said that the Coca-Cola vault can only be opened with a resolution from the board of directors of Coca-Cola, and that no more than 2 employees ever know the secret at one time, and they are not allowed to fly on the same plane together. So if the plane goes down, the secret, would be lost if they were both in there. At least this is what they say. Of course, when I hear that, I think, but wouldn't the formula still be in the vault even if the employees were in the planes that went down? But that's a very extreme measure, and it's what they tell you, when you take the tour. So, you can acquire legal protection by having your employees, of course, sign a non-disclosure agreement saying they're not legally permitted to divulge information. I suspect you all are familiar with KFC, and KFC has a secret recipe that goes into its fried chicken, or at least it's supposed to be a secret. Colonel Sanders supposedly developed this recipe, and he was the founder of KFC. But back in 2016, the Chicago Tribune reported that the reporters had been shown a family scrapbook or a couple scrapbooks that included what might have been the secret recipe. So the cat, I suppose, may be out of the bag. But I always like bringing that up. So here are some questions for consideration for your weekly discussion board. The first one is, what can be copyrighted? We talked about that at the beginning of this lecture, and it's important to understand what can be copyrighted, and of course the second one, which is what can't be copyrighted. And what is the distinction between those two groups? That's something you're going to want to really be thinking about, because I'm going to ask you about that on the final exam. Is it necessary to register your copyright? And what are the benefits of doing so? So think about this. Do you think that there are certain companies that probably have to copyright things immediately because they know that their competition is likely to create something similar and they want to make sure that they have the rights first? I think about this a lot because I used to work in Orlando, Florida, which is home to Disney World and Universal Studios and SeaWorld, and they often apply for a lot of patents on new rides and names of new rides. And so Florida, as I previously mentioned, has really good open records. So you often can go in and kind of figure out what is coming to the theme parks based on looking at what they've registered with the copyright and patent offices, especially related to like technology being used in different rides and kind of what is coming in the future. What is fair use? And why is it hard to know whether fair use will apply in any given situation? And the last one, do you believe that protection of patents, trademarks, and trade secrets benefits companies, consumers, both companies and consumers? Why or why not? All right, I hope that you're having a great day. I hope you're having a great week. I'm going to put a couple notes about kind of the last couple of weeks of the class as we begin to wind down the semester.